Welcome, everybody. Thank you for joining us today for next webinar in our series of different pockets and pieces of the proposed regulations. Before we get started, I do want to do some quick housekeeping reminders. If you can, and if you're listening by phone or whatnot, or on the computer application, mute yourself. That helps reduce and eliminate any background noise that might be disruptive to the presenters here today or to others listening in. Also, if you are also working on listening to the webinar and participating, but also going through some stuff on your phone or a tablet, I just ask that you keep that device, if possible, away from the computer or phone that you are listening in to the webinar from. We have had problems in the past with those devices interfering and providing feedback during the presentation. So just being cognizant of those items if you can throughout the presentation today. Also, you have a chat box on your screen. That's the best way to enter questions to our presenters throughout the webinar today, and they will get to them at times when they are comfortable doing so with their presentation materials. Just a reminder, last week we did a webinar on providing an advisor choice for both complainants and respondents in the due process era. This is the next step, next webinar that I've pulled that might be of interest or topic for you. Many of you may have seen in the proposed regulations that there was an opportunity possibly to choose between the standards, but what that would mean. So I'm very thankful to our friends at Bricker and Eckler for joining us today to give kind of their overview and thoughts for those conversations. Hopefully you are already having on campus or will be having very soon. This is not intended to be advice from them or from me or the Department of Higher Education as to this is the standard you should go with, but instead it's just framing up those arguments, thoughts, considerations, things that you should be taking into account if you are exploring that discussion as we await the final set of rules from the U.S. Department of Education. So again, this is not intended to be a directive or advice. It is just simply a review of things that you should be taking into account and consideration if you are looking at that section of the proposed regulations in particular. So without further ado, I will turn it over to Melissa Carlton and Kate Davis from Bricker and Eckler and let them get started. Thank you again for doing this today.
Hi. So don't worry, Carrie, because we will not be providing any firm guidance one way or the other in terms of preponderance or clear and convincing because we're both lawyers and our favorite answer to everything is it depends. Right, Kate? So, I've been doing
area.
It is definitely an evolving area, and I think we're all kind of waiting for where these regulations are going to shake out before we take too many broad steps here. So let me introduce myself very briefly. So I'm Melissa Carlton. I am an attorney at Bricker and Eckler. I do primarily higher education law, and I wear two hats in the Title IX arena. Sometimes I am doing investigations on behalf of some of our investigative clients, and sometimes I am doing general counsel work and helping schools develop their policy. So I see it from both ends, both in the trying to develop policy and the trying to implement the policy as someone who's trying to follow it to the best that they can. Kate, do you want to introduce yourself?
Sure. Thanks, Melissa. Hello, everyone. My name's Kate Davis. I am also a lawyer at Bricker and Eckler out of the Dayton, Ohio office. So I do a lot of work in Southwest Ohio, and I, too, serve the dual role for Title IX cases where I've served as kind of a behind-the-scenes counselor in cases and then as the investigator for different institutional entities. And then I also do a lot of labor and employment work for public entities and policy development.
Right. So Kate's going to keep me honest on the labor and employment because that's definitely not my side of this. I usually just do the employment piece, but not the collective bargaining. So, all right. So we thought we'd start with some thoughts, just kind of gathering to what are the competing perspectives, and there are. I think if you talk to people on your campus, you will find that people have a lot of anxiety about what standard of evidence is going to be used in these cases, and for good reason. People, number one, want to make sure that things are clear so that they know what to expect going into the process, and number two, they want something that's fair. But fair is always in the eye of the beholder, and sometimes whether something is fair analysis is conducted after the process is over and people are looking in hindsight. So, we kind of recognize that it can be a moving target as to what might seem fair to any person on a given day. But ultimately, that's what we want to reach. We want a standard that we consider to be fair under the circumstances. We want to make sure that the people who are in charge of making the decisions about cases on our campus are correctly applying the standard that we choose. And we want to find a standard that's going to best serve the many needs of our campus community. So you've got a lot of stakeholders on campus that are going to be interested, and we want to find a way to engage those people with the hope that you get buy-in ultimately with what you end up doing. So on the right side of the slide, you'll see too high of a standard may result in some unacceptable behavior not being addressed. So this is a false negative, right? We have too high of a standard of proof, and therefore we can't meet it to find the behavior violated a policy, and therefore we can't issue discipline. And in some of those cases, discipline may ultimately be appropriate. We just don't have the evidence. That's always the risk we run anytime we run through a fact-finding process, is that we may not have enough evidence to prove. You see criminal cases all the time, right? There's a sense that the person has done it, but they can't get to a beyond a reasonable doubt standard. And the reason that we've chosen such a high standard in criminal cases is because the penalty for that is often jail time. And in some cases, we have the death penalty still. So we want to set that, we set that standard high for our criminal cases, in part because, we have this theory underlying our criminal system that, it's better to let 9 guilty men go free than it is to convict one, innocent person. That sort of standard. So that's the analysis that we run in the criminal process. But when we choose the standards as evidence, we have the same sorts of things, like the risk of a false negative. On the one hand, if you have too high a standard. On the other hand, if you have too low of a standard, it may result in some acceptable behavior being subject to discipline, right? So we want to make sure that we're not getting false positives where we're disciplining people who ultimately shouldn't be subject to discipline, because in the end, in the kind of the truth with a capital T that exists out there that we can never know, maybe that person does not deserve to be disciplined. So these are the things that we're trying to consider from the get-go. And on the overlay of this is, of course, what are the legal requirements? That's what we're going to talk about today. So, Carrie, do you want to go to the next slide? So when I was in law school at University of Pennsylvania out in Philadelphia, I was on the student conduct committee for graduate students, and I had zero experience in any realm of the conduct system. So the entire process, when I got tapped on a hearing, was new to me. So I remember sitting in this hearing panel discussion. It was me and a bunch of faculty members, and the standard that they were using for the particular case we were hearing was clear and convincing. And the person who had been conducting the hearing gave us a definition of what it was and then left the room so we could deliberate. And the first thing that happened in the deliberations was the professors all looked at me and said, "So what does clear and convincing mean? Like, really?" So, which was not
very nice.
Well, right, and also kind of alarming that they were relying on, at that point, a first-year law student to explain a standard that I don't actually know that I had encountered at that point in my legal education. And so I was like, well, I think it's like 80%. Like, we're 80% sure. And so that's what we applied. So that should alarm anyone who runs hearing panels, the fact that the hearing panel wasn't entirely sure, and that was probably a one-off situation and some grumpy professors besides. So we had a lot of dynamics going on in that situation. But I wanted to draw it out for you. So if we have the 50-50 mark being the center of this slide, preponderance of the evidence, you'll see I tried to make it line up as close as I could just to the right of the 50-50 line. It is a more likely than not standard. So when you get to preponderance, anything to the right of that would automatically qualify as preponderance, but we can go all the way down to just above 50-50, the more likely than not. Clear and convincing is a little bit more nebulous of a standard, and it turns out I was actually right about the standard, thank goodness. So a lot of people will describe it as being somewhere in the neighborhood of 67% to 80% sure that a violation has occurred, which is why I've kind of given it a range. And then beyond a reasonable doubt is what we use in our criminal cases. It's like a 95% certainty. Some people say, well, what's on the left of the line? So I'm like, my 5-year-old describing what happened at school yesterday is going to be like, I'm not sure we're going to reach preponderance of the evidence to determine whether that's true or not, right? So it's a lower level of halfway. And so we're all on the same page. If you hit 50-50, you have a tie, and if there is a tie, there is no policy violation. It's very, very rare that we have a true tie, but it can happen. So, you have to get to preponderance at this point in our system to find a violation. So if you want to go to the next slide, Carrie.
And Melissa, I can just jump in because just yesterday I was presenting on this to a group of school administrators and talking about this preponderance standard. And I find myself, maybe I'm a hand talker anyway, but I have to always hold up my hands, on a horizontal plane to demonstrate the preponderance of the evidence. And so we talked about that. And afterwards, one of the employees came up to me and said, well, I don't understand, if you don't reach a preponderance of the evidence, so you decide that there's no policy violation, how can someone still say that someone engaged in inappropriate conduct? I had a feeling this was a personal, scenario to her. She didn't say that, but she was questioning me. How is that possible? How could in a Title IX investigation report there be, notes of evidence of certain wrongdoing, but that they still found there was no policy violation? And so we had a discussion afterwards about how just because, you could still have some evidence of wrongdoing or inappropriate conduct or unprofessional conduct, but it still may not rise to that 50% or 50%, plus 0.001 standard. And so we had an interesting discussion about that. So I just thought that was kind of a very recent real life question I had about that.
Yeah, no, that's helpful. And, it's picturing you in my head, because I'm a very visual person, trying to balance the scales, horizontally for the preponderance of the evidence. Well, it reminds me, I've explained when we do our trainings for investigators and hearing panels that preponderance of the evidence is a tip ever so slightly in the more likely than not direction, whereas clear and convincing, it doesn't require any special math or calculations to see that the scale is clearly pointed in one direction, right? And beyond a reasonable doubt would be practically it's sitting on the ground. So if you're a visual person and that helps, maybe that's the way to describe it. We find ourselves struggling with how to explain it in a way that will make sense, particularly because all of these situations can be very complex, and the people that we have making the decisions, sometimes it's people that do it every day as part of their jobs, and sometimes it's people from across campus that may not be involved in this sort of decision making every time. So I thought, well, what does the what do the Ohio jury instructions say? So when we put 12 people from random walks of life into a jury box and ask them to make decisions on preponderance of the evidence and clear and convincing, what does that say? So this slide includes the Ohio jury instructions for preponderance of the evidence. These are just the pieces that are most relevant. They're actually longer than this, but it's described as the greater weight of the evidence. They're the evidence that you believe because it outweighs or outbalances in your minds the evidence opposed to it. It's more probable, more persuasive, of greater probative value. And you're looking at the quality, not the quantity of the evidence. So just because someone musters all their friends to say one thing happened, that may not be of the same quality of evidence as someone else's story in the context of the same case. And so this is where, you get deep into the credibility questions, right? Like what evidence is corroborated by other things, what is consistent with other things, all of those. We're learning how to line those up on the scales. But this is what the jury receives. So, Kate, when you were describing it to your people yesterday, did you have any catchphrase that you use for preponderance of the evidence? Because I don't find this to be particularly easy to understand.
The way this maybe wasn't the most eloquent, but as I had my hands up, in the horizontal line, I said, as an investigator, I'm looking for something that can push me over that edge. It's almost like the edge of a cliff where I have to have something to push me just beyond the edge to get there. It doesn't have to be big, but it has to be enough to do that. That was my way of describing it, and I think they understood that.
Right. And you can see how in a case it's word against word, it's going to make people uncomfortable that might be the standard in some circumstances. So, all right, so go ahead and go to the next slide. And we've got the jury instructions for clear and convincing evidence, right? So this is the evidence must produce in your minds a firm belief or conviction about the truth of the matter, and it must be more than evidence that simply outweighs or overbalances the evidence opposed to it. So again, I don't find this direction particularly helpful because it feels like, well, the snarky response to what is preponderance of the evidence is usually like it's 50% plus a feather. And then the second part of this definition leaves me, well, is it 50% plus 2 feathers? I don't think that's really the correct, clear, and convincing standard. So, if you go back to the first piece, the evidence must produce in your mind a firm belief or conviction about the truth of the matter. I actually think that's kind of a more helpful way to envision it. But it's still difficult to understand what evidence is going to be crossing over that line. So, I'll be frank, I don't typically have to describe that standard much because there aren't a whole lot of institutions in the state of Ohio that use it. And there's not a whole lot of institutions or a whole lot of situations where it comes up in any circumstance. So we'll talk about that in a little bit. And I'm sorry, Kate, were you saying something?
Oh, yeah, just thinking out loud that I could see problems with consistency using that. I mean, from within one institution, if there are several investigators doing this work, trying to apply this in a consistent way, that seems problematic to me. So if people have experience with that, I would love to hear about it.
Well, and that rolls us into our next slide, which is that we're always concerned in any situation involving adjudication that we're using the standard that we say we're going to use. So, and you see this in criminal cases all the time, right? Like, you'll hear jury members come out of a criminal case afterwards and say things like, I really think that person did it, but I just couldn't send them away for the rest of their life, right? It's that sense of, well, if you really think they did it, then why are you considering the consequences in the way that you're implementing the standard? And that's really my concern here. A lot of times when people get the preponderance of the evidence standard and they recognize that the possibility at the outcome of the investigation may be that someone is suspended or expelled, they may feel uncomfortable only using the more likely than not standard. They may say, I'm really looking for that firm belief. Like, that's really what I'm looking for. And so while they may say that they're using the preponderance of the evidence standard, they may be looking for that firm belief that we're not expecting them to look for. And to the extent that it falls somewhere between preponderance of the evidence and clear and convincing, and they find that there is no violation, that's problematic, right? Because if we're telling our campus community that this is the standard that we're using, we want to make sure that people truly understand the standard. And I know one of the ways that we do this in our training, we train all our internal investigators the same way we train our externals at our clients, is we run them through scenarios and we talk it through. Are we at preponderance? And the way we do this is we write a scenario that is as close to 50% as we can get it, and then we talk it through with the people in the room to see where they come out. And what's interesting to me is how we've done this scenario where people will interview various complainants and respondents, kind of a mock interview setting, and then they'll take the information from those and we'll try to make a decision off of it. And the way that a complainant or respondent can present things, or that the words that they use to describe it, can make a huge difference in the preponderance of the evidence application. So you can see how that is in any situation that you can probably call to mind. So whatever standard you ultimately choose and whatever standard you're using now, I think it's important to touch base with the people making those decisions regularly to make sure that they are being consistent in the way that they are approaching it. Like Kate just said, if there's a worry that people aren't applying it consistently, then are you going to get certain investigators at your institution that have a reputation for going one way or the other, and that's going to create problems for you down the road. You don't want anybody to feel like the identity of the investigator is what determines the outcome of the case. So I don't think you can train people too much on this. I don't think you can run too many scenarios and talk it through. Does that sound right to you, Kate?
It does, yeah. And I'm thinking from the employment side of things, I'm just, if any of our listeners are at institutions with unions, I can imagine the disparate treatment claims that would happen if someone is disciplined under a bargaining agreement by one, due to the investigation by one person, and then a year later something similar comes along and there's a different outcome. That would be just another layer of complication.
And transparency a lot of times in these cases can be the best way to deal with those sorts of situations, but the confidential nature of all of these investigations makes it difficult to be completely transparent in the way that we might otherwise want to be. So anytime that we don't properly explain how we got an outcome, that's going to leave a question mark in people's minds that they will fill in with whatever seems reasonable to them. So if that's, I'm being treated differently because of a protected trait or because of some sort of other factor that's inappropriate under your policies, that's going to stick with people and it undermines your process. So that consistency is important. So I put together a brief hit standards. Back as early as the mid-90s, the U.S. Department of Education was issuing some documents that were sent to individual schools that suggested that preponderance of the evidence was what they were looking for, and that actually continued through from the Clinton administration to the Bush administration. So we have seen administration without changes in enforcement necessarily. But in 2011, I think, was the first time that it was laid down in paper in guidance from the U.S. Department of Education that said the preponderance of the evidence is what we expect you to be using on these Title IX cases. And I put the exclamation there because when this came out, it was a big deal. It was a sea change for a lot of folks. And for some people, it wasn't as big a deal, but this was a definite statement by the U.S. Department of Education that it's time and this is what we're going to lay down. So 2016, we got a Sixth Circuit case on the standard. We'll talk about that in just a second. That's why there's an asterisk there. But know that we're one of the few courts, we're one of the few jurisdictions in the country that has anything that we can rely on in terms of preponderance of the evidence standard being appropriate for these cases. So 2017, we had an administrative change, and we got our new Q&A document from the U.S. Department of Education that, as you all know, withdrew our 2011 guidance, gave us new information that said you can use preponderance, you can use clear and convincing, but whatever standard you choose to use needs to be consistent across the board for the different types of misconduct. It's kind of a broad statement. Now, the proposed regulations that, again, have not been adopted, and it could be months or years before we see a final version of these regulations, you can use preponderance, but only if you use it across the board for all types of student, faculty, and staff misconduct. And we'll talk a little bit in a minute about how to make a determination as to what kind of standards you have going for you in your different policies. So let's go ahead and talk about the case here just very briefly. So it's the next slide. So this is Doe versus Cummins. You see that it is a Sixth Circuit case. It's actually fairly recent in the world of Title IX. 2016, but it is also listed as a federal appendix case. You can see them in the citation there. So what that means is the case is unpublished. The court, for whatever reason, said we're not going to send this to the official federal reporter, so it gets picked up for publication by the federal appendix, but it doesn't carry the same precedential value as it might have carried if it was a regularly issued decision. So we have it there. It's good persuasive authority. The Sixth Circuit may rely on it in future cases, but it's not quite as much gospel as it would be if it was in a regular federal reporter. So this was a University of Cincinnati case in which there was a preponderance of the evidence that was used in the sexual misconduct cases. I think there were two cases in this particular situation that involved two separate students who had been subject to discipline. One person had been suspended. The other person had to write an essay or something like, or they were on probation. It was something much more minor than separation from the institution. And so they challenged the decision on a variety of levels, and one of them was, we don't think the preponderance of the evidence is the appropriate standard to use from a constitutional due process perspective. And now you will remember, public institutions have to comply with constitutional due process. Private institutions are typically held to the standards that are guaranteed in policies for their campus communities. So it's a breach of contract standard for the private institutions. So for public institutions, we're looking at it in a constitutional due process way. And so this is the quote from the case. Allocating the burden of proof in this manner, in addition to having other procedural mechanisms in place that counterbalance the lower standard used, such as an adequate appeals process, is constitutionally sound and does not give rise to a due process violation. So I think the court was trying to say is, you have a preponderance of the evidence standard that was pretty low, but because you have an opportunity for an appeal, that counterbalances any chance of a wrong decision. There's additional process that's being provided. So that's what we have from the Sixth Circuit. So if you want to go ahead and go to the next slide, you'll see I've stamped it, not the final word. So elsewhere in the country, we have a lot of discussion going on about what standard to use. And there is a definite movement in the litigation that we're seeing, particularly filed by respondents, that say that clear is an appropriate standard under a due process analysis. They don't feel it's appropriate to use the preponderance of the evidence. And courts are starting to really seriously consider this argument. So even though we have an unpublished opinion from the Sixth Circuit, I'm not going to feel like that is the final word until we either get a published opinion from the Sixth Circuit, or ultimately if we get a circuit split, which means two circuits disagree and the Supreme Court decides to hear the case. So, there's the case law standards that apply to you, and then there's also the regulatory standards that may apply to us in the future. We'll talk about that in a minute. So I tried to list some of the common arguments here that I hear on campuses for or against the preponderance standard. So most civil cases are, in fact, decided using a preponderance of the evidence standard. If you go in and you file a complaint that says, this person has wronged me and I have suffered emotional distress, that's a tort case. It's going to be a preponderance of the evidence standard. If you have a contract dispute, it's most likely going to be a preponderance of the evidence standard. If you think back all the way to O.J. Simpson, beyond a reasonable doubt, he was found not guilty of, murder, but his wrongful death lawsuit was decided using a preponderance of the evidence standard. So a lot of people say it's just like every civil case. And in fact, that's the argument that we heard a lot back in 2011 when it was moved to that standard in the guidance. The flip side of this, obviously, is that not every case, most civil cases are decided using preponderance of the evidence, but not every case is. And typically, the cases that use clear and convincing evidence are cases that have a heightened risk of loss to the respondent. So situations in which you might get your children taken away, or you might get your license that's necessary to practice your profession taken away. So you'll see in the commentary to the proposed regulations, they actually cite an Ohio Supreme Court case that used the clear and convincing evidence standard in a case involving a lawyer who was alleged to have propositioned a client. And that clear and convincing standard actually wasn't related to the fact that it was a sexual allegation. It's related to the fact that anything that you bring to potentially get an attorney disbarred is going to be using clear and convincing. So, if you're going to lose your medical license, all of those things are using clear and convincing. And so what some people will say is that, we think that losing the ability to attend school at a particular institution and kind of the black mark, if you will, that is perceived to follow that person, perhaps in applying to other schools or applying to graduate schools, that seems to us to fall into the same category of that heightened risk of loss to the respondent, right? So there's this balancing. What's the right answer on that? I don't know. So another argument people use for preponderance is that most of the cases that we deal with, particularly in terms of sexual assault in colleges and universities, tend to be word-on-word cases. We have one person and another person in a room together with no other witnesses. And while we can track down witnesses that saw them before they went into the room and saw them after they left the room, there may not be any witnesses that can help us corroborate the evidence of what happened inside that room, which makes it very difficult to address any behavior that may occur under those circumstances. And I'm sorry, I'm a huge Hamilton fan. Every time I give this part of the talk, I sing The Room Where It Happens in my head. So I apologize. I'm definitely picturing Hamilton at the moment.
Don't sing it to us. That's okay.
I will not sing it because I'm kind of losing my voice. Otherwise, I might be tempted. So we've got the situation where a lot of people are concerned about the one-on-one cases that are developing and the inability to address those. And they're saying the only way that we can meaningfully address those situations and change campus culture in a not trademarked by the Ohio Higher Ed Department way, right? Is if we have the ability to address those in a meaningful way through the process. And using preponderance of the evidence standard is going to allow us to really address those misconduct that occurs in those situations. It gives us a better way to address it. So they're looking really to make sure that they don't have false negatives. The flip side of that is the false positive argument, right? If you've got a false positive argument, that needs to be taken into consideration too, because the risk to the respondent of a false positive can be a real thing, and that can be very detrimental to them. So we've got this back and forth argument. The third argument that I've heard, and the one that kind of gets me personally, is it's the standard that OCR uses, right? That they use preponderance of the evidence to decide whether a school has complied with Title IX. So if a complainant and a respondent are in a room together and you adjudicate the case and one of the parties doesn't like the way the case comes out, you may do that under preponderance of the evidence, but then OCR is going to review that case and determine whether you are compliant or not. So, that's the standard that OCR is using. What's the argument against that? I don't know. Part of me says if you're going to take federal funding from an institution and not allow any of their potentially thousands of students to access federal student aid because of something that happens in a word-on-word case, and you want to make the argument that a clear and convincing standard should be used in those cases, then perhaps it's appropriate to use it with the schools too. And I know that's something that has been raised in some of the comments to the proposed regulations. So.
Hey, Melissa. Actually, I was going to ask you that because sitting here listening, I'm curious and I don't mean to steal your thunder for your next webinar about the proposed regulations, but I'm curious. Yeah, have you seen much discussion in commentary or that sort of thing about is there some kind of compromise position about different standards in different cases? Is there any much support behind that kind of argument, or is it going to be all or nothing? One standard for everybody, and that's it.
So, okay. So I guess in one way, from a practical perspective, from a clarity perspective, I would prefer an all or nothing one way or the other. If they're going to take a stand, then it makes sense to take a stand one way or the other. Think about it. If you use, let's say we say, okay, for some cases, we're going to use clear and convincing. For other cases, we're going to use preponderance of the evidence, and we're talking all sexual misconduct cases, but maybe we're going to divide it along some lines. I'm thinking that now your liability as an institution lies with whoever makes the decision about which standard to use, right? And in most institutions, when we're making a decision about how to implement the policy, that's going to fall on the Title IX coordinator's shoulders. So to me, that gives me pause for concern. It's also just not a very clear way to do things. I said out of this whole regulation process, what I would really like is for our clients to be able to pick up the regulations, understand them, and know how to implement them without having to call us, right? Like that would be the gold standard in clear, understandable federal regulations. That's hard for any agency to meet, which means I'm probably going to stay employed, I think, for a little while at least. But that would be what I'd like. And when it's clear for the institutions, it's also clear for the people involved in these. And clarity is so important in people feeling that they understand the process and that they feel in control of their role in the process. So I'd have to look really careful, but I haven't seen any good ways of dividing up some things are preponderance and some things are clear and convincing. And given the proposed regulations suggesting that they really do want it to be used across the board, I'm not seeing a strong push for compromise provision yet. So, but, I am still reviewing comments to the proposed regulations, we've got a webinar that Bricker's going to be doing on Friday that's at noon and also free, and you can get to on our website. And they are the comments are really broad. People are coming at this from all different perspectives. So it could be that I run into something in the next 2 days. Okay. So go ahead and take the next. So we're at this odd point, right? We've got people on our campus that are wanting to change things, and people that are really starting to think deeply about this, partly because of the proposed regulations. Maybe you've had something happen on your campus that's kind of raised the profile of the dialogue. And all dialogue in this area, to me, can be good and an opportunity to educate our students. You can get them thinking deeply about how they want to interact with this system, and it's always better to do it on the front end than the back end if we can, right? But we're also at this awkward place where, I think most of our clients, at least that I've talked to, Kate, are hesitant to make any major changes to their process until they get proposed regulations finalized.
I'm with them. I think
right. I mean,
who wants to stick their neck out?
So, building consensus on your campus to make a big change can take a long time. And if you go through that process and you do it appropriately and you get everybody on board and then the regulations come out opposite, you're going to have a whole bunch of people on campus potentially angry at the way the regulations come out, angry at the system. I don't know that that's going to be a good thing. But that's not a reason to not have the conversations, because no matter what ultimately we get, I think having people think deeply about these things is going to be a benefit. So what do you do now while we're waiting for the proposed regulations? So right now we still have the guidance in place that says, you can whatever standard you use is the same that you use to address all discipline. It's more specific in the regulations, but arguably that might be just a more specific way of phrasing what's already in the guidance, if you want to think about that for a second. With the, there's definitely some nuances in those regulations. But so what do you start with now? So gather your information, all of it. And this can be difficult depending on how your campus addresses how it publishes its policies, right? So you have staff, you have faculty, you have students. You may have other groups on campus that also have disciplinary policies. So I've run into situations where certain departments on campus may have their own set of disciplinary policies, particularly if they have a high use of temporary employees, such as summer employees. Maybe your Res Life group hires a large number of summer people to come in and do things. They may have their own handbooks. You may have a lot more handbooks than you think. A smaller campus, you may just have a faculty handbook, a student handbook, and maybe some staff policies through HR. But you want to gather all of them together. You want to see what standards you're using in Title IX cases. You want to see what standards you're using in discriminatory harassment cases that don't involve sexual misconduct. You want to pull the standard that you use to address student academic misconduct and potentially if you have a research misconduct policy. Those tend to be standards that, at least in my experience, may sometimes be set higher than your typical conduct cases, right, because we're talking plagiarism. So you want, as was the case in my undergrad or my law school, right, that they were using a clear and convincing standard, and the case that I was hearing was about academic misconduct. So we want to make sure that we're pulling from all these places, faculty cases, and those can be difficult to track down the standards because you may be talking about standards that apply when you're dismissing a tenured faculty member for disciplinary reasons. They may be different standards for if you're not granting tenure to a faculty member for disciplinary reasons. So you have to be kind of creative about what are all the different ways that we may address potential misconduct on our campus and what standards are we using. So think very, very broadly on that. And one way to do it, get on your website and do a Google site search on preponderance of the evidence or clear and convincing and see where the standards come up. While you're doing that, you can also Google things like Title IX and First Amendment and make sure that you're getting all the answers that you're expecting on those things too. But I think this is important. You got to get it all in front of you because the first question that I would be asking if I was your general counsel is, so what standards do you currently use? Because that may dictate ultimately what your options are, right? If you have clear and convincing Well, let's put it this way. So Kate, if you've got a collective bargaining agreement that sets a standard for how these cases are going to be handled, how easy do you think it would be to negotiate that?
I mean, I think that would be really difficult because I think a lot of bargaining agreements would use a just cause standard and look to, arbitration decisions as to what that means, not necessarily, Ohio civil law, tort standards. So good luck bargaining that with your union is what I would say.
Right. So, and one of the things that always strikes me, is if you're trying to change the standard of evidence that might be used in like a faculty case or a union case, I think there's a lot of there can be some thought by that entity, the faculty or the union, that we don't want a lower standard because we don't want to make it easier for our people to be disciplined. But on the flip side, they're just as likely to be potentially the complainants in these cases too. And so some of their members may ultimately want a lower standard. It's kind of an interesting way to split it. Mm-hmm. Yeah, but I don't think you can begin to solve any of those problems until you figure out what it is. And ultimately, if you get a really good, consensus building process on your campus, you may be able to get everyone on the same page, even if that means giving up things giving up a position one way or the other that they find valuable, if that seems to be the consensus of the community. So, okay, so go ahead and go to the next slide. So what is the how do we get consensus? And I'll tell you, this looks different on every campus that we work with. I think some of our smallest campuses have a very, very, how do I say it? They can say things and it happens, right? They can pass a policy and it's a very quick process, right? The administration can get on the same page in one meeting and roll it out to campus, and there's not a lot of pushback. That is not the case in all our campuses and in every situation. I think some of you are probably like, yeah, that's not my case here. So, Kate, I know you have a good story about consensus on campus.
Melissa and I were just chatting before the webinar started, and I was saying when I was working with a large public university on some policy, I was really shocked when I learned the process to change a policy had to go through the faculty senate. And I didn't know what that really meant. And so I, being the dutiful lawyer, marked up a copy of the policy in red line, and I made all these fabulous changes. It was an acceptable use policy. Things that are pretty typical from an employment law perspective of things you'd want to have in your policy for your staff members and faculty. And I didn't think it was really even that big of a deal. And it came back, and pretty much everything I wanted was completely shot down by the faculty. And it was not going to happen. I mean, that was that because they had the power to say no, and that was hard for me to wrap my brain around. So it was a learning experience for sure.
Yeah, so I think anytime we step into the higher ed world, as a private entity, we work for a law firm, we work for a consulting company, and both of those can easily, you need a policy. We don't think that this is meeting the legal standard. The lawyer writes the policy to meet the legal standard, and it's in place immediately. And that is definitely not the situation in all of our campuses. So we recognize that, right? And so a lot of campuses, we have to do what we call the world tour, which is you're going to go talk to all your stakeholders and make sure that you have people on the same page to the extent you can. So I tried to list out here some, faculty, staff, students, parents, alumni, board members. They can be particularly important stakeholders, especially if they have to ultimately vote on the policy that you're adopting, depending on what your governance model is. You may have victim advocates that work on campus. You may have defense attorneys that also can be good resources for you. And, of course, a lot of that depends on your the relationships in your community and that sort of thing, but they can be helpful, particularly where students who identify as victims or students who have been respondents in cases may not want to necessarily publicize that and go join a campus-wide committee where they can offer some valuable input. So you want to identify who are the different populations on your campus that need to be involved, how can we get them involved. It says consider diversity populations. I should say diverse populations. You have lots of students from, you may have international students that have different perspectives on they may have a different civil process back in their countries. This may be entirely foreign to them. So you may want to think broadly about who you include. Do you want to form a committee? Do you want to have open forums? How are you going to solicit input, and how are you going to teach people, right? So I think, if I were to get on Twitter right now and say, I have this important national discussion and I would like people's input on how we should solve this, I think I would probably get a lot of responses that would not be, shall we say, up to the level of nuance that I might want on a particular national problem, right? People come from all different walks of life, and they may have opinions, but that doesn't necessarily mean that their opinions are well informed. So if you go ahead to the next slide, I think the thing that you can do now is if you know that this conversation is coming, you have to start with the education. You have to get the community talking about it in a way that is thoughtful, and that is not, hopefully, if you can do it, hopefully that it's not fueled by a particular case that is the hot button topic on your campus at the moment, right? So unfortunately, whatever is the most immediate need, a lot of times there's a tendency among campus communities, different stakeholders, to say, well, we're going to fix it so that doesn't happen again. And the way that we're going to do that is to go one way or the other. And so what we want to do is we want to educate people outside the context of a particular hot button moment and try to get them engaged in a conversation that's a little bit more balanced and less emotional than they might be if they feel that a particular person on their campus has been wronged one way or the other. So think about panels, think about discussions that you can have. And if anybody has a particular educational program that they've run on this topic with their campus that they think has been helpful, feel free to post it in the chat, because I would be curious to hear what other campuses are doing. But, once you have people talking about it in a way that is meaningful, that's the point where I think if I'm building campus consensus, that's the point where I start thinking about, okay, now let's write a proposal. And I would want that proposal to be broadly supported by different people on campus. So this is, to me, is like, this is time for a committee. This is time for some people that are respected across campus and can also represent a diverse group of views to tell us what do they think is appropriate and why, and then solicit feedback on that. And then we're finalizing the policy language once we have. So it's really not any different than notice and comment for the federal government. I mean, there's a reason why that's codified into law, that they have to go through that process, is because they do want that kind of breathing, that feedback back and forth among the stakeholders. The thing that's not in notice and comment is trying to get your community to understand the issue before they comment, right? So that's what we're trying to add in here. We're educational institutions. Fundamentally, we want our students to go off and be good citizens and understand how to be good citizens at the end of this. And so I think that education piece is important. And then you want to think about, does your board have to approve your policy? And also, should it approve policy? So sometimes people will say, does my board have to approve? And we'll pull out governance documents, look at policies on policies and that sort of thing. And we'll say, well, maybe your board doesn't have to approve it. But typically, if you can get your board in line with a course of action that you're going to take in a very high risk litigation environment, that may provide you with some better support when ultimately, knock on wood, but you can do everything right in the world, and it may end in a lawsuit anyway, because ultimately it's someone's life that is being affected, and they may want a way to address that. So think about whether you want to have your board to approve, and if so, then think about whether you need to include a board member on your committee so that they can be the one that presents it to the board in conjunction with you. So where does the issuance of the new regulations fall into your phases? This really depends on what your campus is looking for right now, right? So if this is the discussion that they all want to have, that's great. But hey, we're sitting in the Sixth Circuit. The discussion they might want to have might be that they really feel like we need to address the cross-examination issues, or we need to address how we're going to make sure that each party has equal access to an advisor. That may be what your campus values are. So this isn't, at this point in time, as long as you're in compliance with the 2017 guidance, I don't know that you have to rush forward and have this discussion if there's more pressing needs on campus. But certainly as we get closer to final regulations, I don't know that you're going to want to let this situation that you're going to want to not talk about this ahead of time, right? particularly because we don't know how much time we're going to get to comply with the final regulations when they're released. We all hope that they would give us at least several months of leeway so that we can rewrite policies as they may be necessary. But we don't know for sure yet. So having some preliminary discussions on campus may ultimately put you in a better place at the end of this. And then do you feel the need to make the change absent any new regulations? There's nothing that says you can't. As long as you're within the guidance from the 2017 policy, there's nothing that said you can't. And certainly I would continue to watch case law. This is developing at the rate of like a decision every 2 days in this area of law. It's exhausting as a lawyer to try to keep up with it and process it and try to figure out how to advise clients on it. So, to the extent that you've got access to webinars or, you're going to conferences, I think all of that's really important because particularly here in the Sixth Circuit where they've been very interested in kind of the nitty-gritty of the process, I think we're absolutely going to see decisions on this, which may ultimately decide the question for us, right? But if your campus community is demanding some sort of change, I think it's good to keep your ear to the ground and be cognizant of that, but not to automatically implement a change because a vocal group is being heard. If you haven't engaged to make sure that that's truly an across-the-board consensus that's being built, if that makes sense. Am I making sense, Kate?
I think so. I think so. There's not a bright line rule that everybody should rush off and change their standard, but it's certainly not premature to start thinking about this and engaging stakeholders in a conversation.
Right. So when you go into bargaining sessions, is this something that you're starting to think about at least having preliminary conversations about, or is this not where unions are at the moment?
I think this is not where unions are at the moment. I think they would, my sense is I think they would be actually pretty surprised. I think this could take them by surprise. So I think it's probably a good idea if people have bargaining coming up and want to, to at least talk about it at the table. Maybe it's not even at a proposal stage, but just kind of plant the seed that, hey, these proposed regulations are on the horizon. So just a heads up, we may need to be talking about this in the future.
So in the phases that I've laid out here that kind of involves the entire campus community having a discussion about this, how would we fit that process in terms of like the mandatory duty to bargain collectively? Do you have any thoughts about how to integrate those two things?
Well, I think there's nothing, anything on your slide here from I represent management, so I say this is fine. Go ahead and do. I think you do it and see what they say. But no, a more objective perspective might be as long as you're not implementing a policy at this. You may have a due. It depends on, frankly, some bargaining agreements do say policies have to be run by the union, run past them. Right. So, that might be something you have, but some don't. So I think it really would be a case-by-case basis. But my kind of overall gut reaction to this is I would proceed and kind of see what pushback you get.
Right. No, and yeah, I wear a management hat a lot of times too, so I just want to make sure I'm not like overly consensus building. So maybe the message is if you have unions on campus, right? Like if you have unions on campus, go talk with your labor people and make sure that they are a part of designing how this process is going to work so that they can trouble spot any of the labor issues that they think might arise as a result of this discussion. Because the last thing you want to do is get to the end and be like, we have built campus consensus and here's our policy language, and the union says, and now we're filing an unfair labor practice against you because we don't like the process or we think you didn't bargain the wage. Right, exactly. So, yes. So there's nothing that can be easy on campus when you're talking about so many different perspectives, but it's such an important thing, I think, to address, and it will have a material effect on the way cases come out, because anything between that 51% and that 80%, the choice of standard is going to make a huge difference. So do we have any questions at this point? I know we're getting to the end of our hour. Oh my, it's 12:57 already.
Yep, I have not seen any questions come through yet, so if anybody does have questions, now's the time to kind of enter them into the chat box and get some thoughts or feedback on anything that Melissa and Kate have covered today, or anything that may be weighing on your mind or has come up in your own conversations, if you've already started these on campus.
So I did get a private message from somebody in the process of this. So we were talking about clear and convincing standards being used in a lot of licensure cases. They sent me a quote from, it looks like an article on physician discipline that talks about how it's common for physician cases to involve sexual misconduct when we're talking about licensure issues, but the article quotes, it says, a study commissioned by the U.S. Department of Health and Human Services found that 2/3 of the states used the preponderance of the evidence standard in this circumstance. So that would be a really interesting study to read, I think, and potentially instructive in terms of what we adopt into the Title IX standard. And from an employment perspective, like in a Title VII case, completely private entity not subject to Title IX, like the law firm where we work. Title VII applied to sexual misconduct, and those cases are decided on a preponderance of the evidence standard. So just something to keep in mind. All right, so I see a question. Do you have I have two questions. So I think some of them are coming in as private questions. So how can a school tell if their decisions are creeping into a standard other than the standard required under their process? So I think there's no perfect scenario to be able to tell, but the way to me to monitor it is to have those continuous dialogue conversations with the people that are making their decisions and with the people that are investigating your cases, if those aren't the same individuals. I think, table-topping case scenarios is such an important way to train people, but also to check people, which is why when we do our 2-day investigator training and we have our investigators sit through the second day, we do a scenario-based training the second day because we want to make sure that they're that even our own people are using the best judgment that we think they can take with them into an investigation, right? So if we start to hear people that are making comments that seem to us to be biased in any way, even, implicitly, unconsciously, that's the opportunity for us to address them right there. And I think it's the same way with a standard of evidence. If you're using a scenario that really challenges the line at 50-50, it causes people to be more specific in the way they're justifying the way the decision comes out. And it's verbalizing that can give you clues as to whether you have some more education to do there. So there's no magic, but more conversation. And, some people are like, oh, my goodness, conversation training. I feel like that's all I do. With my general counsel hats on, I will say that someday, may you never be deposed, but if someday you are deposed, one of the first questions you're going to be asked is to explain your education training experience. And ultimately, your life will be much better if that's a very long conversation rather than a very short conversation for everybody that you put forward, right? That training is not just going to help you do your job better, but it's also going to help defend your cases better should they be challenged in a court of law. Right. So, question, do you have a format to start introducing this information to unions and executive staff? I think, if you've got unions, and that's a key thing on your campus, Kate, how do you have that conversation? What do you think about at the beginning?
I think, I view collective bargaining as very relationship-driven. So there's probably more than one way to skin the cat, I think. But my approach, if I were to do it, would be an informal approach at first, because I think this is still pretty early, right, in the process, assuming that you are just starting to think about this. I think it'd be different if you have a draft policy ready to distribute. But I would want to start early with conversations with the union reps, in an informal way. I don't think it even needs to be part of bargaining. I think it would be, a side conversation, but I would just want to, keep the lines of communication open and so that they understand you're not trying to, slip something past them, right? That this could actually be an opportunity to work together to get to the right answer. That's how I would approach it.
I think that's true of everybody, right? It's a transparency thing. The more transparent you are about the process, ultimately, the more people will accept the end result no matter which direction it goes. So, and executive staff, they're probably already thinking about this and commenting on it. I mean, when we did when the proposed regulations came out, we had a number of webinars that were kind of addressing those sorts of things. And we saw lots of people from across campuses. I recognized names from clients, and I could say there were people who were at the top level of, kind of the cabinet, so to speak, but there were a lot of people that were on the ground level of things who maybe have aspirations to work up there someday, or who just have an interest in the question. So I think, these conversations, the interest is there. I don't think there are a whole lot of people who don't have opinions in Title IX these days on a college campus. So it's an easy way to start the discussion. And I just got a private message, and I would agree with this advice. So there's a person named William Kidder, that's Kidder, that has a proposed article that's kind of a working paper. And actually, I was reading it last night. It was helpful to. Actually, I was kind of mad I didn't read it before I wrote the PowerPoint, because we kind of tracked the same things. It would have saved me a lot of thought. But he talks a lot about the false negatives and false positives and some of the considerations, and also he gets more into the allegations or some of the arguments in favor of or against, and whether those play out once you start digging a little deeper into the research. So I will be curious to see how that paper might develop over time. It's available online now if you search for his name at ssrn.com. So if you're interested in this, you kind of want to watch how it goes. That might be a place to get some more in-depth information.
All right. Not seeing any additional questions on my end, and you didn't have any more on yours?
I don't see any. Nope.
Awesome. Well, Melissa and Kate, thank you so much for your time today and for sharing this information with us. I really do appreciate it, and I'm sure many who participated did as well. So thank you again for your time and your support of our campuses here in Ohio. We really appreciate it.
No problem. We appreciate it.
Thank you.
Absolutely. Have a great day, everyone. And if you need anything from me, ksolar@highered.com, ohio.gov, sorry. All right, talk to you later. Bye.
Bye.